So Judy, whom can I will? Whom can be a beneficiary to my will?
Good question. The law says that a will maker has what we call complete testamentary freedom. You have freedom to will your property as you wish, complete, except that you have to provide reasonably for your beneficiary. There is no requirement that a will maker should be fair, but they should provide reasonably for their beneficiaries. So who are those beneficiaries that they must provide for? So they must provide for their children. They must provide for their spouses. Okay? There is a legal obligation for them to do so. And if they do not reasonably provide for their children and their spouses, then the law or the court can adjust the will so that reasonable provision is made for the person not provided for. There's a case where the judges said, we don't know why the will maker provided very generously to his last wife of 3 wives. So even as we adjust the will so that we can make reasonable provision for the first and second wife, they still made the wife provided for the majority beneficiary. Do you see what I mean? So they will intervene to make reasonable provision, but they do not have to make equal provision, because the clause is that you must reasonably provide for your people. So once you reasonably provide for your children and your spouse or spouses, then you're at liberty to provide for anybody else. You could provide for a cause, that you believe in. You could provide for anything that you want to, provided that you have covered yourself by reasonably providing for those who are your beneficiaries under the law.
That's very interesting, because I go back to sometimes I wonder, what is reasonable?
So reasonable will depend on the circumstances of the matter, because you see, each case stands on its own facts. There are factors that the court considers in considering what's reasonable provision. And one of the questions you've got to answer, again, this is set in the law, is have you been previously provided for? You see, what are your needs? You see, what does the estate constitute of? Stuff like that. What was your relationship with the deceased person? Even that is asked of you. So taking all the circumstances into consideration, the court should be able to arrive at what a reasonable provision should be. The discretion, I can tell you this for free, is completely upon the judicial officer deciding the case, because no two cases are the same.
So what happens if the beneficiary of the will dies before the willer?
Okay, that's a good question, Ken, because if the willer has not named a default beneficiary and the beneficiary they have named in the will dies, then that gift is said to have failed, you see, because there is no one to take it. So that gift can go, it will go to intestate succession. When you have a will, we say you have died testate. When you do not have a will, we say you have died intestate. And it is possible to even have a combination of both testate and intestate. And it is an expensive, unnecessary process. So if you name a person without a default beneficiary and the person you have named dies, then that gift will be dealt with as if you had left no will with its respect. You get it? And it will now be divided upon your beneficiaries in accordance with the law of succession, where all those people who do not write wills, their estates go to, or the one that controls the estates of all those people who do not write wills. So imagine a situation where you have a will, but or not all your properties is willed, or not because you didn't name a default beneficiary, or because you left out some properties. And that's also very, very important, that I guess sometimes it's very difficult to put all your properties in a will. And you see, you write your will today and you may not update it for a long, long time. So if you're very, very specific with the listing of the properties, you may have left out something that you acquire subsequently, or something that you're not aware of, or something that you forgot. Now, so we tell people to have a residual clause in the will. The residual clause states that if there's anything that I have not named in this will, then that something should go to, say, my children equally, or to my spouse and my children equally. It's called a residual clause. It means that everything that you have not provided for will automatically go to those people, and it doesn't have to go into the intestate succession. You get it? But if you don't have the residual clause, then anything else other than what you have put in the will expressly goes into intestate succession, and you end up with an expensive, cumbersome process. Yeah.
So can one will property that is jointly owned?
What a good question, Carol. If property is jointly owned between two people, the survivor takes it all. Okay? So that you should expect that if you die before the other person with whom you own the property jointly, that person becomes the immediate beneficiary of that property, even without going to court. And we're going to talk about it more, because it's also one of the ways of estate planning. So your question is, can you will it? Yes, in this way. Because you don't know who will go first unless you do, between you and the other joint owner of the property. So how I do it, I say that I write, I will help people write the following in their wills, that they are aware that they hold property A jointly. And they are aware that if they died before the other person, then the property will automatically revert to that other person. But in the event that that person dies before them, they know that the property will come to them. And in that event, they wish to will it as follows. You see? So you have an if.
Yes.
In the event that it comes to me, this is how I wish to do it. So that is important. The good thing about willing and wills is that if it's not yours, even if you will it 1,000 times, it doesn't become yours. You see? So that even if you put it in the will, but you die before the other spouse, it will go to the other spouse, even though you had written it in your will. Something doesn't become yours just because it is in your will. Yes.
What about land that, for example, has no title, and so maybe it's a lease certificate of some sort? What happens with that?
Okay, even that you can will, and unfortunately the situation in our country and environment is that many of us hold properties or own properties where they do not have title, so to speak. So you should still put it in the will, provide sufficient description, okay, because there could also be a chance that between the time you will it and the time you die, that property could have a title. You see, so it has a number, and you hadn't put the number there. So provide sufficient description if you don't have a title, so that we can know this is a property that you wish you willed to this person, even though it did not have a number at the time. So to answer your question in few words, you can will property that's yours, even though you still do not have a title at that point. Yeah.
What happens when a beneficiary realizes that the property they have been willed is in debt?
So the estate should pay the debt. The estate of the deceased person should pay the debt. Okay, but if there is no other estate, if there is no other property, there is no other money, then you take the property with the debt. Sometimes it happens.
So succession could sometimes translate to
taking some responsibility.
Exactly.
Absolutely. And maybe it's not such a bad thing to take responsibility. It could well be.
Oh, wow, so informative. I have a question.
Yes.
Sometimes you have a will and your children are under the age of 18. How does that transpire? What does that look like?
Okay, so children under 18 cannot hold property. So the executors or the trustees of the will should hold the property until the children become of majority age or of such an age as you have stated there. Because some will makers do not even wish for the properties to be registered in the children's name or for them to have access to the assets when they are just 18, just because they turn the age of majority.
Yes.
For many people, they want them to be at about age 25, when they are responsible.
With good reason.
Yeah, with good reason, absolutely. So the trustees under the will or the executors can hold the assets until such a time as the children are of age. Now, it's then important to talk about trustees. So when you die and you've got 6 feet under or somewhere else, you can't take your will forward. Okay, so first of all, that's when your will, becomes more than a piece of paper, okay, because you've passed away. But you need somebody to take it to court so that the court can give validity to the will, so that whatever your wishes are can be put into effect. So the person that's named in the will to do that is called an executor. Okay, so you can name any person who is an adult of sound mind as an executor, and they should file a petition in court saying the deceased person left a will as attached herewith. We now require probate to this will so that it can be given legal effect, by the law, so to speak. And what the court does is, once you file it, it is then sent for gazettement in the Kenya Gazette. And people are given notice that so-and-so has applied to have executors, to have the will of so-and-so given probate, okay? And if you have any objection, please make that objection within 30 days. Okay, so if there is an objection, then that becomes a case for the court to determine. Some of the objections that one can make is that the deceased did not have capacity to write the will, that the will, the signature is a forgery, all sorts of things, that the will has not been properly witnessed, okay, and the will is not therefore competent. So then the court takes evidence and hears the objector and where they're objecting to the will. The onus is upon the person who objects to the will to prove it. It's not upon the executor to prove it, it's upon the person who objects to the will to prove it, on a balance of probabilities, as we say, okay? So if the court then finds that the will is competent, the court will issue the executor with the grant, with the power, to move ahead with it, and eventually the court will distribute the properties in accordance with the wishes of the person that has passed away that are contained in the will, okay? So that is the process of executorship in a nutshell. Now, a person may leave a will but not name an executor. So who should take this will forward, and who will sign for the transfer of properties from the deceased person to the beneficiaries? Because, by the way, that's what the executor does. Not only does he take it to court, he also gets the power to distribute the property, so that if it's money in an account, he's the one who go to talk to the bank, give them documents, the bank will confirm that the documents are valid, legal, etc., and then do whatever it needs to be done in accordance with the will. So when there is no person appointed as an executor in the will, because some people leave that out, then an administrator will be appointed. An administrator will be, it can be a member of the family, okay, who and provided that they are of adult age and again of sound mind, they can be given the power to administer that will. So they take it to court, they say, here's a will that was left, there was no executor named, I'm applying to be the administrator, I have the consent of the family, and once they're given that power, then it's, and then it's gazetted. If there is no objection, then they are given the power to administer the will in accordance with the wishes of the deceased person.
So the executor cannot be a beneficiary?
The executor can be a beneficiary. It can be a beneficiary. In fact, many times, as spouses will name each other as executors, or they'll name their children as executors. Remember, the executor is just doing what the will tells them to do, by the way. And let me tell you, no land officer, no bank will do anything else than what is contained in the will that the court has given validity to. So the executor actually has no discretion, no sway whatsoever, other than what is contained in the will. And the beneficiaries are involved at every stage. They will give a nod. This is what the will said. We agree, we agree. And if we don't agree, then the case will be determined. So where a beneficiary feels that they were not reasonably provided for, they can make an application to court before the will is confirmed, and the court can make provision for them or disagree with them, and as the case may be.
A little bit on these children who are below 18, and sometimes this property is left under guardianship of some form. Can you tell us a little bit more about that?
Yes, so two things is that a willer or a person making the will, and I always say that parents who have children under 18 should do this. You can appoint a guardian for your children, okay? And the appointment of guardian can be done by way of a will or by way of a deed. A deed is a document, you know what I mean? It doesn't have to be a will. It can be another document called deed, and which is properly signed and witnessed, where you appoint a guardian. Because, I mean, nobody knows when their maker will come for them, you see? And there are things that you could tell people about your children under 18 that would help in achieving their best interests, okay? So I think that's critically important. So when you appoint a guardian, you're giving power to that person to intervene on behalf of your children should it become necessary to do so. Even if the other parent is alive and is available to the children, it is not a bad thing to appoint a guardian, because should there ever be need to intervene on behalf of those children, either with their parent or beyond their parent, then you have a person that you have clothed with the legal authority to do so. Yes, yeah, absolutely.